Now, I want to emphasize that the reason we do this is because recognizing and acknowledging that we reside on the lands that are not our own is a first step forward in reconciliation between Indigenous and non-Indigenous peoples. The significance of a land acknowledgement is essentially to show recognition of and respect to Indigenous peoples and their traditional or ancestral territories, which are essential elements of establishing a healthy and reciprocal relationship. So as this meeting is virtual and we are not all gathered in the same space, we recognize that this land acknowledgement might not be for the territory that you are currently on. We ask that if this is the case, you take the responsibility to acknowledge the traditional territory you are on and the current treaty holders. I recognize that many Indigenous nations have a long-standing relationship with the territories upon which we are located that precede the establishment. We recognize and acknowledge the presence, our presence on the traditional territory of many Indigenous nations. The area known as Toronto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It is now home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject of the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. So today we will have Jay present first, Sebastian second, and Sandra third. I would like to take a moment to introduce them. So Sandra, oh, sorry, let me start with Jay. That would make more sense. Jay is a Canadian philosopher whose publications include Displacement by Development, Ethics, Rights, and Responsibilities, Human Rights, India and the West, and Theorizing Justice, Critical Insights and Future Directions, and the 2019 Routledge Handbook of Development Ethics. Jay is a professor of philosophy at Carleton University in Canada, and he has served as the president of the International Development Ethics Association and president of the Human Development and Capability Association. Awesome. You know, I think maybe what we'll do is I'll introduce each presenter as they present so that we don't, I don't introduce all three at the same time. And with that being said, I will be keeping time. I believe, I'm so sorry, I'm trying to pull up how long each presentation is and how long each question period is. Diane, I'm so sorry. Do you mind stepping in and reminding us how long each presentation will be?
Yes, of course. Hi, everyone. So the presentations are going to be 20 minutes, and then we'll have 10 minutes for question and answer. And you might have seen in the chat, please type out any questions that you have throughout the presentation. And then after, Karina would be happy to read out your question, or we could unmute you and you could present your question as well.
Thank you so much.
No problem.
All right, and with that, I'll pass it on to Jay. Thank you so much.
Hey, thank you so much for the lovely introduction, Karina, and thanks to Diane and others who've made this possible. As you can infer from my background, that is the background picture of this video, I'm coming to you from the unceded territory of Algonquin people, currently known as Ottawa. Let me switch now to the slides. And excuse me for 1 minute. There. Okay, so first I'd like to make a shameless plug for the PhD program at my university. We have a multidisciplinary ethics and public affairs PhD program at Carleton. So if you know of any MA students who might be interested in this, the application deadline is January 15th. They can find more out about it by either emailing me, getting the spelling of my name from the slide, and Googling me at Carleton University. So what I'm going to present to you, let me say a little bit about the context where this piece comes from. Capability and oppression. As Karina mentioned, I've been elected as the president of the Human Development and Capability Association. And one of the perks of that position is you get to give a presidential address. So what I'm going to give to you is about the first half of that, 40% of that perhaps. And so I'm really looking forward to your best questions and criticism. Put them in the chat. If we don't have time to discuss them all, then I'm going to get them via the chat, and it'll be very helpful to me as I revise this application. So begin with two portraits of oppression. And the first is by a very famous philosopher. It's a very famous metaphor in the thing on the left. And by Marilyn Frye. And she wrote in 1983 that the experience of oppressed people is that the living of one's life is confined and shaped by forces and barriers which are not accidental or occasional, hence avoidable, but are systematically related to each other in such a way as to catch one between and among them and restrict or penalize motion in any direction. It's the experience of being caged in. All avenues in every direction are blocked or booby-trapped. Now, the second portrait I'd like you to consider is Martha Nussbaum's portrait of Jama, a woman she interviewed in the South Indian state of Kerala. In her middle 60s, no longer able to perform the physically taxing job of brick carrying, Jama has no employment to fall back on. Her husband never supported the family much anyway, and now he has died. She is unable to collect a widow's pension from the government. The village office told her that he was ineligible because she has able-bodied sons, although, in fact, her sons refuse to support her. At the same time, her daughters, who are more than willing to help her, have very restricted skills and opportunity. I thought that the life of Jama fits very closely with Marilyn Frye's image, famous image of oppression. It could be worse for Jama. At least she has her health. She has good relationships with her daughters and granddaughters. And another part of the passage that I didn't quote tells us that she has housing which is clean and cool with basic services. And yet her hold on some of these capabilities is precarious because her income is low and insecure. And here she's stuck. She's unfree even to secure the capabilities that she has, much less to expand them. Marilyn Frye's words are very apt. Jama has the experience of being caged in. All avenues in every direction are blocked. Now, Nussbaum is certainly not the only capability theorist to discuss and study conditions of oppression. However, capability theorists have not often discussed these as conditions of oppression, and until recently, the word oppression has been largely absent from their vocabulary. It's not indexed at all, for example, in Women in Human Development, the book where Jama's case is discussed. So that struck me as odd. What explains it? Frye may have a ready explanation. To quote her again, the word oppression is a strong word. It repels and attracts. It is dangerous and dangerously fashionable and endangered. It is much misused, and sometimes not innocently. End of quote. Perhaps the founders of the capability approach thought we could avoid these dangers without losing any valuable insights by discussing the condition of people like Jama as unfreedom instead of oppression. However, more recent contributors to the capability approach have not felt so constrained. For example, Jonathan Wolfe and Avner Deschalet, Serene Cotter, and Ingrid Robaines. Well, my message in this presentation is that the capability approach need not and should not refrain from discussing oppression because, in fact, the capability approach has much to say about oppression. So my starting point will be to distinguish between having freedoms and gaining them. In 1824, at the age of 12, Charles Dickens had received a few years of schooling and was an avid reader, but he was nowhere near capable of writing novels. In that year, his father was sent to debtor's prison, and young Charles was sent to board with a relative and to work in a warehouse. While these experiences no doubt contributed to his later capability to write the novels he actually wrote, he did not have that capability in 1824. Fortunately, one of the bars that caged him in 1824 shook loose when his grandmother died. With her estate, his father could leave debtor's prison and Charles' education could resume. Once that happened, his capabilities were no longer stultified the way they were at the warehouse. At that moment, he was not yet free or capable to write novels, but he was no longer quite so unfree to gain the experiences and talents and social relations through which this freedom would expand. Now, I want you to notice that, to reflect if you remember, but the word free was used twice in my last sentence. The first time, it meant being free to function in some way if one chooses. For example, being free to write novels. The second time, it meant being free to gain that first freedom. And this is an important distinction. And in capability language, the difference is between having capabilities and being free to acquire them. These are different freedoms, different real opportunities supported by different circumstances. And so I'd like you to consider a couple of more examples. The first one is the freedom to sing in a choir. A first order freedom, being capable of singing in a choir, means being a member of a choir, being accepted for one's voice, ear, and musicianship. Your voice and their acceptance are what make this a real opportunity. The second order freedom, becoming capable of singing in a choir, involves further steps, usually auditioning, possibly taking lessons. To change examples, being able to read is a first order freedom. It means that if we see the symbols, we can recognize the words and sentences they represent. Gaining the ability to read is, of course, different. That is a different real opportunity involving teaching and learning. The freedom to gain literacy is a second order freedom. Second order freedom, second order unfreedom, it seems to me, is where we find oppression. Fry's metaphor of being caged or confined conveys this vividly. The Cambridge English Dictionary adds, oppression, the word oppression, refers to a situation in which people are, to quote, prevented from having opportunities and freedom, end of quote. So provisionally, oppression can be conceived within the capability approach as a second order unfreedom to expand capabilities that people have reason to value. Now consider what's wrong with oppression. In earlier times, it might have been more obvious what is wrong with oppression. One dictionary lists unjust or cruel exercise of authority or power as its meaning. Another includes tyranny as its meaning. So if oppression is necessarily cruel or tyrannical, then this presupposes an oppressor who is capable of vices and virtues and who oppresses knowingly. Yet, as Iris Marion Young has observed, this stereotype of oppression as cruel, tyrannical, and deliberate is not at all consistent with contemporary conceptions of systemic oppression, which can result from, to use Young's words, the normal processes of everyday life in which people are simply doing their jobs or living their lives and do not understand themselves as agents of oppression. In other words, the agents whose choices originate or implement systemic oppression may not be cruel or tyrannical at all. And if we can no longer point to such vices, how shall we say what is wrong with oppression? Well, part of the answer, I think, does point to the capability outcomes. What is wrong with oppression in part is that oppressed people's capabilities to live well are stuck at low levels, so that they are unequally and unnecessarily unfree to live well. And surely if the capability approach has anything to say about oppression, this has to be part of the answer. On the other hand, just as surely there must be more to it than this. The idea of having capabilities that are stuck at low levels captures the idea of confinement, and that's lamentable, possibly tragic. But to see what is wrong with this, we must look deeper into the background to see whether anyone else's agency is involved. The capabilities of Sisyphus surely got stuck at low levels once he was confined to endlessly pushing his rock uphill. But to know whether this was wrong, we need to consider the source of his confinement, and that, of course, was his punishment by Zeus. Systemic inequality is even more complex. What Zeus did to Sisyphus was altogether deliberate and intentional. In doing it, he achieved a goal that he had reason to value, and that goal was meting out punishment, ending the bad behavior of Sisyphus, specifically by restricting his agency to pushing a rock uphill. Some of the agency that causes inequality is like this. The causes of racial inequality do, of course, include racists and racist thinking, but much of the agency that causes systemic inequality is quite different. When people contribute to systemic inequalities, they are acting on purposes, but often their purposes are not focused on restricting the choices and advantage of others. In other words, contributions to systemic oppression can be quite unthinking. Consider three illustrations. First, and I got this from one of my PhD students who has just retired as a civil servant in Ottawa. It was common in one government department to call last-minute meetings at 4 o'clock. The managers who called these meetings were generally oblivious to the problems they were causing for those staff members, mainly women, who had to pick up their children from daycare after work. Second example, one factor that has contributed to discriminatory housing patterns in the United States has been white flight. When white people leave a neighborhood because they perceive an influx of Black people, their minds are focused not on restricting the choices or advantages of their new Black neighbors, but on preserving what they perceive as an advantage for themselves. Third example. Discriminatory housing patterns also contribute to environmental racism, including greater exposure to air pollution. So imagine a civil rights lawyer who chooses to drive to work and to meetings and appointments because public transportation in his or her American city is so poor. The lawyer, whose goal in life may be to fight racism, nevertheless contributes to environmental racism by adding to air pollution while driving to work. So in all three of these cases, an agent does something that has the effect of disadvantaging people. The action serves a purpose, and yet that purpose is disconnected from the people who are disadvantaged. In the purposes and goals that these agents are trying to achieve, the very thought of restricting the agency or advantage of others is not present, or at least not prominent. When inequalities are produced systemically, there is this disconnect between the agent's goals and these effects, which may also be disconnected in the further sense that it's not possible to trace the causal chain, for example, between one person's driving and another person's case of lung disease. Some oppressors of course, do aim to restrict the agency and advantage of people they oppress, and we should not overlook the fact that racism, patriarchy, caste hierarchy, and so on are implemented intentionally by some people. But systemic oppression also results from a whole lot of agency that is not intentionally oppressive, but is disconnected from its oppressive effects. So this raises a challenge. Because of these disconnections, these agents of systemic inequality are not strictly liable for the disadvantages they contribute to causing. The absence of strict liability challenges us to think, is nothing wrong with systemic discrimination except the outcomes? Well, I think the key to answering this challenge is to observe that even when there is no strict liability, there is still agency. Compare this with harm done by a machine. If workers are injured because their clothing gets caught in the works, what we attribute to the equipment is not wrongdoing, but malfunction. Or if we do find wrongdoing, it's not in the functioning of the equipment, but perhaps in its design. Wrongfulness is not involved unless agency is involved. And if agency is in any way involved, then it is relevant to ask if the process was wrongful. So too in the case of systemic inequalities. Disadvantaging people can be wrongful if the agents are not aware of who they are disadvantaging or how. What makes wrongfulness relevant is simply that agency was involved, that the inequality resulting from actions by which people sought to achieve goals, that the inequality did in fact result from actions by which people sought to achieve goals that they actually valued. Now, I think of this as a supplement to the moral approach that Iris Marion Young proposed towards systemic oppression. Young framed the problem this way. If we cannot identify particular agents as strictly liable for inequalities that are generated by complex social interactions, it may seem that no one is responsible and nothing is wrong. However, we only reach those conclusions if we insist on looking for strict liability. This ignores a different form of responsibility, which may be more relevant, and that is the responsibility that you or I or others can take based on our ability to make changes in the world. This has often reminded me of Sen's occasional comments that can implies ought, meaning that we have an obligation to make the world better in ways that we can. I fully support this shift in thinking about responsibility. However, it still leaves a blind spot in our assessment of how oppressive practices are wrongful. It does this by basing assessment of oppression entirely on the outcomes and ignoring the causal background of agency that makes those outcomes happen. So it's important to insist, therefore, that two things are wrong with oppression. One is that oppressed people are less free to live well. The other, not to be overlooked, is that being oppressed, being stuck in this condition, results from the agency of others. And that is my conclusion. Thank you. I look forward to your questions.
Beautiful. Thank you so much, Jay, for such an enlightening talk. I will turn the floor to our audience. If you have any questions or comments, please type it in the chat. I see that Sandra has already come up with a question. Oh yes, please, if you want to clap, we can do the no sound hand clapping reaction in Zoom. Thank you so much. Okay, so let me read out Sandra's question. She asks, Jay, is systemic oppression intentional when we know it exists and we omit doing what needs to be done to make it stop?
Okay. If we know it exists and we don't do anything to make it stop, well, it's still important to distinguish between passive Okay, I know how to get to this. Every form of oppression is specific, right? So when you want to look at what makes people unfree, what makes this oppressed group unfree to expand their capabilities, there are specific theories that are involved, right? So with the case of First Nations, it has to do with their historic dispossession and also their denial that they're being denied the rights of peoples to self-determination. And there are other things that go along with that. Now, with racism, I find there are two main theories going. One of them is relevant here to Sandra's question, and that is that racism. This goes back to Carmichael in the 1960s and 70s, and that's the idea that we have racism results from collective agency. Okay, so collective agency includes some active agency on the part of out-and-out racists, but this can result in systems that, you know, are embedded in regulation and procedure and so on, and then people can be employed to carry those procedures out, and it may not be their intention, but they have to do it because it's part of their job. So, and then what about, yeah, I think the stark distinction between intentional and not intentional, we need to dig deeper than that, right? So there are anyone who contributes to racism in any way, either by simply reproducing it, or simply by seizing conditions of their own advantage when these are in short supply, right? There was a series in the New York Times about how, you know, middle-class white parents are able to seize educational advantages, right? And the title was Nice White Parents, right? Because that's how they were perceived by the teachers, who then, you know, gave additional support to their children. The point, so that's why I want to, I think it's, let's look at the different degrees and ways in which people contribute, and not focus so much on whether it is topmost in everyone's mind. I mean, yes, when racial attacks are topmost in someone's mind, then that is much worse, and we need to recognize that. But we also need to recognize that even the passive contribution, you know, needs to be accounted for. And what I'm trying to do is to say that in all these grades of responsibility, people are, I'm saying two things, okay? The first thing is that people are doing things for their own purposes. Their purposes may not be racist purposes, but the things they're doing are contributing to racism, okay? And then the part that I didn't give you here is that it happens that decisions that one group make affect, by limiting, decisions that another group have, right? And that, with a few additional qualifications, is, I want to define that, I think that will define subjection. So again, it may not be domination. Domination is when there's clearly individuals who are in clear positions of power over other individuals. Systemic inequalities are different than that, but still there's relations of agency. and there's a relation of subjection. And I think that's what we need to get our minds around to understand what is wrong with systemic oppression. So thank you for your question, Sandra.
Great. I love that thorough response. We have a few more questions in the chat. The next one's a little long, so I will read it out, but if you can follow along in the chat, that'd be awesome as well.
Okay.
So Michael Luoma asks, Dear Jay, thanks very much for this very clear and engaging talk. Can the capabilities approach explain what is wrong with settler colonialism? My worry is that incorporation of Indigenous people on equal terms into the settler state, reconciliation as equal citizenship in the settler state, would be sufficient on the capabilities approach to relieve Indigenous people from oppression. Does the capabilities approach help us understand the sui generis harms of colonialism, which seem to require some reference to Indigenous group agency, territorial rights, and political authority? How might the capabilities approach help us explain these colonial harms?
Okay, really good question. Yeah, my concern was that if we're only concerned with low capabilities, then we're putting every poor person, looking at them in the same way, and we're failing to capture what is specific to different forms of oppression. So what I'm suggesting is that it's not the case that the only metric for inequality here is capability. Doesn't have to be, right? Sen talks very clearly about another metric, which is agency freedom. And so what I'm suggesting is that all the specificity can be found in the domain of agency on freedom, or how some people's agency freedom is used to make to deprive other people of agency freedom, which is just what I said before, that the choices that some people make reduce the choices that other people have. Okay, so you're quite right that we can't just say bring out yet another capability metric and put it in the Human Development Index and say this explains what's wrong with oppression of Indigenous people, because it has to do with the means. And I have a good colleague, actually where I presented this, the conference, it was an online conference, but the hosts were Massey University in New Zealand, which, if you know, is a university that is specially tasked with providing post-secondary education to Maori communities. I think this is a pretty good way of accepting how essential it is for First Nations to be self-determining. And the way I would do that is by saying, look, it was by, among other things, why are capabilities so low in First Nations communities? What is the key to raising them? What is the key to making First Nations free to raise their own levels of capabilities to live well? One very key element is their self-determination, right, in matters of development. This, of course, is also acknowledged by the Declaration on the Rights of Indigenous Peoples very, very clearly. So I think that if we think the way to get at this is to expand what we think the capability approach is. It is fundamentally about capabilities to live well, but it's not just about that. It's how people's agency, limited agency, can make people unfree to expand their capabilities. That's how I would try to get to it. And similarly, a different story needs to be told for every different specific kind of oppression.
Great. Okay, so we do only have about a few minutes left, like 2 minutes left, but perhaps we can go through one more question. So Robbie Dillon asks, I wonder if you misspoke when you mentioned historic dispossession of Indigenous peoples. Is it not important to acknowledge that said dispossession is ongoing?
Yeah, add 2 words, and continuing. Yeah, sure.
Awesome. And the next one, Alex Mayhew asked, I find your distinction between first and second order capabilities interesting. Can that distinction be applied to other instances of the capabilities approach, like health justice, for example?
Absolutely. So, you know, I think one of the good things about the capability approach in health is that it actually does focus on what's important. And what's important are health outcomes. Are we actually free as we could be to keep ourselves healthy? It's not just about the means, right? It's not just about health services. Of course, access to health services should also be equal. Yeah, but the thing is that there are, what makes people unfree? What makes some people less free to be as healthy as others? And there's tremendous group inequality here. You know, it comes out in some of the most blunt indicators, like life expectancy. You know, the life expectancy of Inuit and First Nations and Métis people is much lower than the Canadian average. And you know, if we had better data, we could make similar comparisons about specific diseases. So why is this? Well, part of it, you know, can be the unequal access to health services, but you know, there is a social gradient of health outcomes, as various people, Sir Michael Marmot, leading name among them, my capabilities friend Sridhar Venkatapuram, in his book on health and human capabilities, has stressed poverty itself, you know, I mean, where you fall on the income scale correlates and has a causal impact on your comparative freedom to keep yourself healthy. It has an impact on health outcomes. So we need to, how does that work? Well, it's that a lot of your choices are limited by your income position. So too, a lot of your choices that you could make for keeping yourself healthy are limited by other types of social positioning, right? Being a woman, belonging to a lower or Dalit caste in India, being LGBTQ limits your choices. So the question is, at First Nations, of course, and a lot of the way in which First Nations people's choices are limited has, of course, been spelled out for all of us in the TRC report. I think that, yeah, health is one area in which the capability approach has a lot to offer, especially when we look at what are the various kinds of choices that people do not have that could be relevant to their health, right? That's an important field of research. Hope that answers.
Perfect. Thank you so much, Jay. So in the interest of time, I'll save Philip's question. I also had a question as well. So hopefully by the end of all three presentations, we have a little bit of time to go back. So thank you so much again, Jay. That was awesome. Thank you for being our first speaker. And now we will move on to Sebastian. So a brief introduction to his work. Sebastian is currently residing in Edmonton, and Sebastian Farkas is a recent honors political science graduate of Acadia University in the beautiful coastal town of Wolfville, Nova Scotia. Shortly after graduating in May, Sebastian has accepted a position with the United Conservative Party of Alberta Government Caucus as the legislative coordinator. My apologies. Sebastian's role entails a variety of roles and responsibilities, but his main duty is to ensure his MLAs are prepared to face the challenges of today, tomorrow, and beyond. Sebastian plans on attending law school, where he hopes to specialize in Indigenous, environmental, and constitutional law. Awesome. And now I'll pass it over to you.
Thank you so much, Karina, for the lovely introduction. And thank you so much to Diane and CSSPE and all of our great presenters today for having us to speak here for me this morning, for others maybe this afternoon. And before I get into the presentation, I'll just share my screen here. One moment. Everyone see it?
Yep, looks great. Thank you.
So yes, the title of my presentation and the paper I actually wrote is Canadian Decolonization, the Path to Indigenous Recognition and Sovereignty. And as we noted in Jay's presentation earlier, this is an ongoing struggle for Indigenous people to be the sovereign entities, the self-determining entities with the ability to use the land in a way that is desirable for them and their people. And as I go on in this presentation, I'm going to be focusing on land for Indigenous people, particularly because the land is so important to Indigenous people because it informs their culture, their identity, the way in which they engage with others, the way in which they interact amongst themselves. And that really needs to be the priority when we're talking about Indigenous peoples and protecting their rights. And I'll just move on to the next slide. But before I get into that, this particular paper that I wrote was actually inspired by Dr. Shiri Pasternak, who actually presented at Acadia University just about, it would be about a year ago now. And she gave a presentation particularly on the way in which decolonization can occur in more of a practical manner, in a way that both the government and Indigenous people can build a mutually beneficial relationship that works on the strengths of both and tries to build a connection in being partners in prosperity. So my research question is one that I think is quite practical and one that really needs or gets to the heart of how Indigenous people can get that recognition and claim to sovereignty they desire within Canadian society. And that's something that I try to venture to prove in the paper that I wrote. And really the main argument is that we need to change the way in which we're adjudicating illegal affairs if Indigenous people are to have their rights upheld, guaranteed, and respected. And really the way in which we must go about that is to not have all these caveats for the legitimate infringement on Indigenous rights. And particularly that needs to happen in the court at the Supreme Court level. And I'll get into particularly how I see that going and how decolonization theory kind of plays out. So decolonization theory, I put a few bullets on there on what I think it entails. And really there's a few different understandings of what decolonization theory is. There's someone that maybe some of you have read, Frantz Fanon, who talks about decolonization theory in his book, The Wretched of the Earth. And I would say that's a little bit more of a radical idea of decolonization theory in the terms of he's looking more for a violent upheaval of the entire system that we've created through colonialism. And that's not one that I particularly subscribe to, but there are those types of opinions. But more of a practical sense, I think that the first bullet there, reimagining the status quo. In order to understand that, we have to understand what the status quo is. And really the status quo is that, and I think this is really, people start to get confused on what decolonization is, and they think it's really abstract. They don't really have an understanding of it. The status quo, for the way in which I'm understanding it, is trying to understand that there needs to be a refinement of the way in which the court operationalizes Indigenous law and particularly the rights that they have within the Constitution, and particularly where rights may clash with the Crown and Indigenous rights, though there needs to be a more consistent upholding of those rights when there may be some clashing. And then decolonization, it's not confined to a singular event. It's this ongoing, consistent resistance and struggle that needs to happen within Indigenous communities to continually kind of fighting against the Crown and the government and their overarching type of power over land and their ability to develop it as they see fit. And I think the last point also is very pertinent in the sense that, having land acknowledgements on the bottom of university syllabi and having acknowledgements like we had here when we began the presentation, those are very important. And I think that those are steps in progress, but they cannot be the ends of progress. And I think that that is really what we have to understand, is that I think that that's where governments kind of get a little bit, or they fall short on what decolonization is. And really the court too, is that we can't have these acknowledgements be the satisfactory indicator that we're decolonizing and that we're recognizing Indigenous law and the rights and their nationhood status that they want. And like I mentioned earlier too, the resistance part is really important, because you continually have to be pushing against the crown and their overarching jurisdiction, because if there's not that resistance, you allow them to almost legitimacy to continually infringe upon Indigenous rights and make the overwhelming precedent that that is all right and it's okay that we do that, despite the fact that we have these constitutionally recognized rights and that we have treaties and such. But moving on here. Now, decolonization theory and the relation to law, I think that really we have to understand that we need to expand the jurisdictional boundaries, in the sense that in Canada, we already recognize a plurality of legal systems with common law and civil law. And we need to expand that to Indigenous people and allowing them and their nations to have the ability to govern in a way that's familiar with them, with their culture and their traditions, and giving them that entrenched ability to do so. And it's important that we make that genuine commitment. It's not only, like I said before, is that it's not good enough to just have those acknowledgements. We need to really have a tangible means of doing that and showing that we are genuinely committed to that. And the power to speak the law is also a very important question, in the sense that just simply because the crown or the government has represents the people and that they represent the majority, and we've recognized and we put this in the Constitution that Indigenous rights are just as important and that they need to be upheld. So I don't think that it's good enough to say that they represent the people of the majority, therefore they have the ability to just dictate or govern as they see such. That's not something that we've established, and that's not something that I think is what we're trying to seek here in Canada. And then the collective decision-making part also is very important. This is something that you see quite frequently with Indigenous communities, and it's something that we need to understand, is that it's not just the court, it's that even our political arrangements and institutions, they might not be the most conducive for Indigenous engagement. And there may need to be some changes in that also. And one of the examples that I think is pertinent is you see that in the Northwest Territories and in Nunavut with these consensus governments, where they don't follow a political party system. They're independents who they don't have any type of political affiliation publicly. They're really just concerned about coming together to try to create decisions that are in the best interest of the people, working together. And John Burroughs, who's also a professor at the University of Victoria, he talks also about how even this importance of collective decision-making is also seen in sentencing circles. So they include a lot of the people who are affected by different when they're in the sentencing portion, where they're trying to make verdicts. They include people who are in the actual case themselves, family members, friends, and try to bring that collective aspect to decisions made in law. And so Canadian treaty system, this is definitely a very complicated and not really the most conducive system for Indigenous people to really flourish and achieve that nationhood that they desire. And really it's broken down into, you have historic treaties, which began really in the early 1700s. And they were based on really improving economic and military alliances. And these treaties were made to really try to improve that relationship to definitively define what the rights are of Indigenous people, what the rights are of whether it was provincial, federal, territorial governments, and to see if there could be some way in which they could kind of coexist in a peaceful manner that works on the strengths of both. And quite frankly, and this is something that Dr. Pasternak writes quite extensively on, is that when these treaties were initially signed, I think there was a misunderstanding of what were the obligations of both Indigenous people and the particular government or crown. This type of misunderstanding has allowed for a lot of different things to occur that definitely don't really sit on the side of Indigenous peoples in trying to ensure that they have their sovereignty and the ability to be self-determining protected. And then about after 1763, many of the lands that were historically occupied by Indigenous people, they did become possession of the crown, and Indigenous people did receive financial support and they did receive reserved lands, but they were giving the crown that ability to really be the final decision maker on that. And that's something that I think definitely has affected that. And really a lot of the issues too with treaties is that there's a lot of these agreements are silent on particular issues. And when they're silent on particular issues, then you have to have someone who's an arbiter to decide, well, how do we determine how this particular instance is decided? So that's another issue there. And then you have more modern treaties, which covered were pretty much post after this historical treaties. And the modern treaties were kind of first set out in a decision, Calder v. the Attorney General of British Columbia in 1973, which recognized the rights, Indigenous rights for the first time. And that was a really significant step, as the decision solidified the entrenchment of Indigenous rights. And really that was then further complemented by having the Canadian Constitution be amended with the Patriation in 1982 with Section 35, and having that firmly recognized within Canada's Constitution. And with these more modern treaties in the Calder case, that actually led to the first modern land claim policy and treaty of James Bay and northern Quebec. And since that time, since this modern treaty process has been in place, there's been 25 treaties that have been signed, and they cover a wide variety of things like political autonomy for Indigenous peoples, uninhibited resource use, financial support, and many other things. And a historian, actually, Ken Coates of the University of Saskatchewan, in a New York Times piece, said that the process of negotiating these land claims, this needs to be a pillar of reconciliation and getting to that point where Indigenous peoples are the final decision makers on their land. And that's definitely crucial. But the issue with this is that these two, the historical and the modern treaties, they don't cover all Indigenous peoples, and there's some Indigenous peoples who are not represented, or they don't have any real representation within these treaties. And in 2016, there was, by Stats Canada said, there was just about over 1.5 million Indigenous people. So what happens to these other communities, these other Indigenous peoples who are not represented or are not accounted for in these treaties? And there's obviously ongoing negotiations with the Crown for that. And if they're not negotiating, they have their constitutional rights, which is in Section 35. And even that, I would say, is definitely not something that they need to rely on. And there's a lot of limitations and gaps in that as well, which I'll point to a few cases as we progress here. And so there's been, as I said, Section 35, there is a lot of debate on the effectiveness of Section 35, the entrenchment of Indigenous rights, and really how effective they are in being respected and upheld. And really, when Indigenous rights are confronted with with particularly large development projects being put in place that are wanting to use Indigenous territory for large, mostly resource development type projects. It seems as though the Supreme Court tends to often rule in the favor of these organizations, and there's really no legal recourse for Indigenous peoples to file it, to have an injunction or to stop those types of projects from being developed on their land. There's no real ability. Once the Supreme Court has made that verdict, there's no real recourse for them to engage in. And this is, particularly in the sense of energy projects, this is something that seems quite peculiar in that we had another landmark case in 2014 with the Sukhothai Nation versus British Columbia. And this was a case that actually clearly defined what the Crown had to do to achieve consultation, or when they were engaging in consultation with Indigenous peoples. And they determined that this definition of a duty to consult meant that projects had to be willfully accepted by affected Indigenous groups. And it wasn't just sufficient for them to merely advise them and saying, hey, we're going to have this project through your territory. That's not acceptable. They need to have the explicit consent of Indigenous peoples to say that, okay, we've advised you, and that you need to be negotiating with them so that these projects can be approved through their acceptance. And this was really important, and something that a lot of people thought was going to be a real important step in the Indigenous relationship and really having a solidification of that sovereignty and their ability to develop lands. But unfortunately, this standard of consultation has been really inconsistently met. And even with the Trans Mountain expansion pipeline that the federal government purchased, in the initial stages, the Supreme Court said that the federal government did not engage in a sufficient amount of consultation to meet that particular standard. And that has not been the only case. Prior to that, there's two cases that I mentioned on the slide there that show that this is a real issue, and it's the Chippewas of Thames First Nation v. Enbridge and Clyde River v. Petroleum Geoservices Inc. And these cases illustrated that the Supreme Court is still willing to let the Crown infringe upon these Indigenous rights by allowing companies to totally disregard what that prior case laid out and what a duty to consult meant. And this is really a precarious, as I said, position that Indigenous people finds themselves in, and what Dr. Pasternak refers to as the Indigenous problem, where there's this selectivity in the way in which Indigenous rights are respected and really implemented. And really, they're only really respected when the stakes, it seems, are very low, and there's not really a lot of consequences on the decision at hand. And moving on, so how would we go about solving this problem? I think that's a question that maybe lends itself more in the Q&A portion, but I think that really we need to first ask ourselves, really, what is the role of the Supreme Court? Is the role of the court to make determinations based on what is in the public interest, or is it simply to apply the law as written in its original construction? And if the answer, frankly, is the latter, and that we say that they're making judgments based on the evaluation of public interest, I think definitely that the rights of Indigenous peoples will continue to be overlooked and continue to be infringed upon. And I think that is not something that we want to pursue. That's not something that we've shown that we want to. And this is really begs another question too, because then if the Supreme Court is going to be making these judgments based on the public good and the public interest, then how are they really any different than the Parliament or the legislature? which is supposed to be the ones who represent the people and would have the most in-depth and most upfront and deep knowledge of what actually the public wanted, rather than the Supreme Court. And really, to try to conclude this, I think that it's pretty clear that Indigenous rights are not necessarily a priority in Canada. And frankly, if they were, I don't really think that Indigenous sovereignty, reconciliation, it wouldn't consume the public attention as it had, and we wouldn't be having all these questions on really why aren't Indigenous people allowed to be the self-determining sovereign entities that they desire to be. And Justin Trudeau campaigned in 2015 on establishing a genuine nation-to-nation approach with Indigenous people. Yet this relationship cannot be achieved if the Crown continues to have this unilateral power over the decision-making process within law. And I think that by decolonizing law, through recognizing the inalienable sovereignty of Indigenous people, and to not have all these different caveats for, well, if it's in the public interest of Canada that we're allowed to do that, I think that Canada could change the relationship with Indigenous communities. And if they are willing to make that, I think that we could definitely start building a relationship that really respects and builds off the strengths of Indigenous communities and what they can provide for society. Now, will Canada make that choice? I think that remains to be seen if they're going to continue to do that. I think history has showed that it's definitely not willing to make that choice at this time. And I think that that's unfortunate for Indigenous peoples who desire to be the sovereign, self-determining people that they want to be. And concludes my presentation. Thank you so much.
Thank you so much, Sebastian. I'll give you the actual sound clap and other people can do their reactions. Yes. So thank you so much for bringing this issue to the forefront, because I also agree this is really important, and what we have in place may be necessary, but indeed is not sufficient. So let's start with a question in the chat. First one is from Sandra. So regarding who has the power to speak the law, since disputes between Canada and Indigenous nations are nation-to-nation disputes, should they be settled in international court rather than Canada's Supreme Court?
Wow, that's a good question. I would say that the issue with the international court is that really I don't really see the real enforcement mechanism. I'm not sure how that decisions in those particular international realms would be enforced. So I'm not really sure how that could occur. I think that really the more fundamental thing is trying to make compromises with Indigenous peoples that really, with both Canada and particular Indigenous communities, that build on the strengths of one another. And it seems as though Indigenous people and the Crown almost feel like they're talking past each other. It doesn't really feel like they're willing to really engage with each other and try to have a meaningful conversation to understand really what's mattering to both groups. And I think that while that's definitely an interesting thought, I'm a little bit skeptical about how that would be enforced and how those judgments would play out.
Great, thank you. We'll move on to Robbie's question. Granted that land is a crucial component of Indigenous identity, although many bands have no or extremely limited physical territory, are there potentially legal avenues or remedies that could preserve indigeneity while land claims are being decided?
I'm not sure about illegal avenues. I mean, one of the things actually that Dr. Pasternak writes extensively on, and I'm quite fond of her writing, so that's why I refer to her quite often, is that if we're in a situation where Indigenous rights aren't going to be upheld, maybe we have to rely on the market for kind of not that that the market would be able to replace Indigenous rights, but they would be able to get some kind of financial resources and supports that would kind of quash a lot of the issues that they have within their own communities. And I encourage everyone to actually go read this article by Dr. Pasternak, and it's titled "How Capitalism Will Save Colonialism: The Privatization of Reserve Lands in Canada." And that's a particular article that I think Dr. Pasternak does a really nice job in trying to be realistic in the sense that we've seen that the Supreme Court is really selective in the way in which they are going to uphold Indigenous rights, and that the market may be a way in which Indigenous people can kind of get to some semblance of the same conclusion that they desire.
Great. The next one is from Destiny Grant. What would you suggest as an effective method to enforce a duty to gain consent rather than a duty to consult? Would we need a constitutional amendment, or could there be another route?
Could you repeat the question one more time? Sorry.
I apologize. What would you suggest as an effective method to enforce a duty to gain consent rather than a duty to consult? Would we need a constitutional amendment, or could there be another route?
That's a very good question. I think that the issue with the duty to consult the case and the verdict that came down is that there's still a caveat in there that says that if there's a particular project that's before the court and there's an argument to be made that it serves the public interest, therefore it's acceptable to infringe upon those Indigenous rights that may be in question. And that is, I think, really the issue that needs to be rectified, because it really putting it in the Constitution, it's shown that it's not working. So we can put it in the Constitution and we can propose as much legislation as we want, but if it's not applied and it's not going to be operationalized in the court, I'm not really sure how effective that will be. So I think that we really just need to stop having all these different conditions on Indigenous rights and really just cut those out and say that no, that you need to actually take the time to prove that these particular projects are going to be beneficial for Indigenous communities, whether it's creating jobs for their particular community, building particular infrastructure projects. You need to take that time, and that can't be having these notions of public interest, which really should be the duty of the legislature, Parliament, to determine, and not the court.
Okay, thank you. Denise Meyer asks, the challenge with adequate consultation is the lack of agreement among First Nations as to just who speaks for the community, elected or hereditary leadership. How do we get past that obstacle?
Yeah, that's a great question, Dennis, and thank you for tuning in today. Yeah, I think that was definitely was an issue that we saw just recently in BC with the Coast Salish people. And really, I think that particular issue is an obstacle that the Indigenous groups are going to have to handle themselves, because I think it comes back to really the issue that if we're wanting to decolonize and we're wanting to give the power for Indigenous peoples to represent themselves, govern in the way they see fit, they are going to need to make those important determinations by themselves. And I think that if we allow them to do that, and we can give them resources to do that, I think that is what we need to do. But that's definitely an obstacle that needs to be addressed for sure.
Okay, and then our last question is from Sandra. Is it Indigenous peoples or us providing the obstacle to moving forward? Aren't the Supreme Court and federal government the agents holding full responsibility for our failure to be just and decolonize?
Yeah, I think that that is definitely a very good question. I think that in terms of moving forward, I think that really there's no doubt that I think it's definitely the Supreme Court that's definitely not allowing the ability for us to move forward. I think that I think governments have done reasonably well in trying to show their commitment to indigenous peoples. And I think that while they definitely, the federal government and the Supreme Court are definitely agents that can help in that process, I think that really it lies with the Supreme Court. And I think that they really have to stop trying to mix themselves in the responsibilities of the federal government, who should be the ones that determine what's in the best interest and determining public opinion, rather than the Supreme Court. And they should just be applying it as it was intended.
Thank you so much. That was great. Sandra, perhaps we'll come back to your question once we have a bit more time. Thank you for understanding. And actually, we'll turn to you now, Sandra Thompson. Let me introduce you. Would you like me to use your I pronouns, or may I refer to you as she, her, and hers? You're fine with that? Okay, thank you. So Sandra is a research affiliate at the Center of Healthcare Ethics at Lakehead University. She was the past president of the Canadian Society for the Study of Practical Ethics, and she's currently a co-editor of the Canadian Journal of Practical Philosophy. Her primary research areas are the rights and philosophies of Indigenous peoples. Her research supports her other research interests, namely in all my relations ethics, global health ethics, and mental health ethics. So thank you so much for being here, Sandra, and I'll pass it on to you.
Thank you. And Karina, I'm going to remind you to give me a sound bite for 5 minutes, because I probably won't check chat. Okay?
Yes, no problem.
Thank you. I want to begin by thanking Jay and Sebastian, because their excellent papers provide a very good springboard for one of the key points that I want to make in my paper. And because it may seem that I am being a kind of negative, providing a negative assessment, particularly of Sebastian's paper, I want to start out by saying that it is an amazing paper and an important contribution to philosophical conversation about how Indigenous and non-Indigenous peoples can have a just relationship. My paper is titled Our Ongoing Failure to Understand the Just Relationship Between Us and Indigenous Peoples. I'm going to begin by reading a brief summary that Kate Gunn provides of the Mi'kmaq Nation's attempt to establish a lobster fishery this fall. This fall has been marked with acts of violence and intimidation by non-Indigenous commercial fishers against members of the Mi'kmaq Nation in Nova Scotia, seeking to carry out their treaty right to fish. These actions and the accompanying inaction on the part of law enforcement officials are a stark reminder that racism remains a persistent part of Canadian society. They also point to another significant barrier to the processes of decolonization and reconciliation: the ongoing failure of the federal and provincial governments in Canada to uphold and implement treaties between Indigenous peoples and the Crown. In Nova Scotia, where the current conflict is unfolding, representatives of the British Crown entered into peace and friendship treaties in the 1700s directly with Indigenous peoples on a nation-to-nation basis. The relationships established under the treaties allowed for the expansion of European settlement into much of Canada. They continue to form the constitutional basis on which federal and provincial governments claim ownership and jurisdiction over most of Canada today. In short, regardless of what part of the country we live in, the majority of non-Indigenous people in Canada owe their right to live here to these foundational agreements. The flip side of treaty rights is the Crown's treaty responsibilities, including the responsibility to ensure that their Indigenous treaty partners are able to exercise the rights guaranteed to them on entering into treaty now and into the future. The source of the ongoing conflict over treaties is the Crown's failure to implement the treaties in a way that allows Indigenous peoples to meaningfully exercise their constitutionally guaranteed rights. I think that Kate and Sebastian are in many ways in agreement with their assessment of the federal government and other governments as well. The reason that I am quoting Kate is because I wanted to begin with an Indigenous voice. And although I, like Sebastian, and in Edmonton today, my home is in Mi'kma'ki, which is the unceded territory of the Mi'kmaq. And I wanted to use their story because their story, their history, our joint history, is the beginning of a treaty process. And Kate mentioned the peace and friendship treaties, which are very much unlike the treaties that Sebastian was talking about in his presentation. So Kate captures some of the most important justice issues involved in the events that were happening in Nova Scotia this fall. I'm going to predict that you will think that in my accounting and discussion of the happenings, I actually am much more strident or difficult for non-Indigenous peoples than her approach. And that's because I work within a liberal theory that's informed by listening to Indigenous voices. But I am still a Western philosopher doing Western philosophy, which means I get to be harsh in my justice judgments. And Sebastian, you actually showed a lot more of the Indigenous conciliatory approach than I probably will in what follows. The rights the Mi'kmaq claim to have their fishery are acknowledged and protected in Section 35 of the Constitution. As Gunn also explains, Canada's Supreme Court affirmed the Mi'kmaq right to a moderate living fishery. Unfortunately, when they exercised their rights, non-Indigenous fishers responded with accusations and violence. They accused Mi'kmaq of endangering the lobster stock and argued, I'm sorry, excuse me. They accused the Mi'kmaq of endangering the lobster stock and argued it was unfair they be allowed to fish out of season. Their violence injured Mi'kmaq fishers and property, including many lobsters, and it culminated in the burning down of a processing plant. Union leaders didn't endorse the violence, but they didn't inform their members of the rights of the Mi'kmaq to do what they were doing. They also demanded to be at the negotiating table when the Mi'kmaq and the federal government settled the meaning of moderate livelihood because of their economic stake in the fishery. Like our politicians, lawyers, and judges, our fishers see Mi'kmaq exercising their rights through the window of what I call a colonial perceptual reality, deeming Indigenous peoples inferior. Only if they cannot see Canada, Turtle Island. Okay, I am not going to speak of Canada in this paper. I call what you call Canada, Canada Turtle Island, to be upfront about the reality of the illegitimacy of Canada as a sovereign nation. And it acknowledges the range of what I call colonialism's injustice mountains that stretch from sea to sea to sea in Canada. And it's only because our politicians and most of us cannot see Canada Turtle Island or the Injustice Mountains that our politicians' omissions and our fishers' actions and complaints make any sense. Both presume that our politicians have the right to govern the Mi'kmaq and regulate another nation's fishery. However, when we remove the inferior-superior dichotomy from our reasoning and we insert unceded land acknowledgements, it's obvious our politicians have neither moral nor legal rights to regulate any fishery in Mi'kmaqi until the Mi'kmaq consent to us fishing and we negotiate our quota with them. This notion of colonial perceptual reality is one, it's a gifted notion that I want to give thanks to Lorraine Mayer for many years ago in our conversations about her book, Cries from a Métis Heart. Excuse me. I'm so sorry. I don't know how to deal with my cell phone. Okay. So I was talking about Lorraine giving me the notion of perceptual reality. Lorraine gave me this notion when she was describing the difference between her experience of racism and my witnessing the racism that she was confronting in the world. I frequently was with Lorraine when she was experiencing racism. And I wasn't the victim of the racist remarks, but I could see with her help, and only with her help, that racism was happening. The notion of colonial perceptual reality is one that I acquired over the years of research in Aboriginal rights through listening to Indigenous colleagues and reading Indigenous scholars. I think that I would credit, in addition to Lorraine, Dale Turner, Saki Chenderson, and Leroy Littlebear, with helping me come to an understanding of how, by growing up in our various communities in Canada, we acquire a colonial perceptual reality, such that we have attitudes that block our vision when we are thinking about anything Indigenous. By attitudes, I mean we have false beliefs, and with those false beliefs come valuings and feelings that block our understanding of Indigenous reality, and may I add, our own reality. They prevent us from seeing how we exist in Canada. In some of the publications and presentations that I've written, I talk about we are in an epistemological kind of cave. And I would now describe it as our colonial perceptual reality cave. And I have worked very hard during my research to find ways for us to figure out we're in the cave. And Diane, would you put up the first slide, please? Thank you. I call this set of statements my colonial perceptual reality criteria. It seems to me that when any policy, theory, or action on the part of scholars and academics is exercising the colonial perceptual reality or influenced by it, we presume explicitly or implicitly that the following statements are false. And actually, I encourage you to see if you agree with me that they're true, because you may not, in which case you have a lot to teach me. At first contact, Indigenous peoples were sovereign in their nations. European declarations of sovereignty did not change Indigenous nationhood. European declarations of sovereignty did not change Indigenous sovereignty. European parliaments did not change Indigenous land title. Indigenous peoples did not treaty their sovereignty or underlying title. In an Indigenous nation, our right to self-governance is a treaty right. I could spend a lot of time justifying any of those claims, and perhaps you will ask me questions that will provide that opportunity. But I'm going to move on, and they're going to stay there. So one of the things that I am grateful for in having Sebastian's paper come before mine is that his paper gives me the opportunity to illustrate what I mean by non-Indigenous proposals or solutions to the, and I'm going to use Dale Turner's expression, the white problem. The problem is not an Aboriginal problem except indirectly. The problem is a white problem, and you can call it white supremacy or racism or whatever you want to call it. But we presume in our thinking about Indigenous people that we are superior, because otherwise we would not presume that they were not sovereign in their nations, that we could declare sovereignty and something would magically happen to make us sovereign, that Indigenous sovereignty could just go away when we made such declarations. Indigenous people, scholars, intellectuals, may have as much difficulty with some of my claims as non-Indigenous people. And that's because their notions of sovereignty, their notion of nation, their notion of ownership of the land or land type are so radically different from ours. But what I'm assuming in my work at this point in time is that if we just do what we know and believe to be right according to our justice principles, then we will be moving into decolonization and a just relationship with Indigenous peoples.
Hey, Sandra, 5 minutes.
5?
Yes.
Thank you. Okay. Avoiding our colonial perceptual reality is the next part of my paper. Our violent protest against the Micmac fishery is deeply disturbing for many justice reasons. More disturbing than Fisher's violence, though, are the omissions on the part of our politicians. Prime Minister Trudeau and his ministers, and I would argue no minister's portfolio is irrelevant to this justice issue. Instead of telling non-Indigenous fishers to hold back, instead of apologizing that they had been slow in defining moderate livelihood, should have spoken with one voice, clearly and distinctly, about the rights of the Micmac Nation to establish a fishery according to their legal structures. For many reasons, including their fiduciary responsibilities to First Nations, Our politicians should not allow any of us to doubt Mi'kmaq Aboriginal rights, inherent, sui generis, treaty, and constitutional, entitle them to establish and govern their fishery. However, assuming the colonial perceptual reality of our politicians and law enforcement persons remains intact, everyone should be sufficiently committed to the rule of law in Canada, Turtle Island, to feel obliged to enforce our Supreme Court's decisions. Our laws were broken by Fisher's violent actions and the omissions of our leaders and guardians. Our breaking our laws prevent Mi'kmaq from exercising the right to fish. Being just and accountable to the Mi'kmaq. My paper contains a discussion of why our act of naming Nova Scotia rather than Mi'kmaqi is one of the kinds of actions that we have taken in our creation of the colonial relationship. Naming Mi'kmaqi, Nova Scotia, presumed rights we couldn't have. We pretended to have decision-making rights about where and how we would live in Mi'kmaqi. Not putting Mi'kmaqi on the world map is part of Britain's unjust occupation, dispossession, and acquisition, to use the word that Jay is using in its very fullest force. We have oppressed Indigenous people in their colonization. I want to get to the conclusion. In some sense, I want to get to the conclusion. Okay. I agree with Sebastian that the wording in the Constitution, the wording in Supreme Court judgments, and even the words of our politicians often make it sound as though we're getting things right. On ceded land acknowledgements, Trudeau's use of the notion of nation to nation and his seeming to see the tips of Injustice Mountains and a willingness to implant the United Nations Declaration on the Rights of Indigenous People and to pursue reconciliation give me some hope we are at least looking for a just relationship. Unfortunately, this year, when we were put to the test on the West and East Coast, our politicians from the Prime Minister all the way down to the provincial politicians demonstrated that we don't see Canada, Turtle Island. Our thinking remains clouded by our colonial perceptual reality. We have not deconstructed it. We have not begun, therefore, deconstructing our colonial reality. Although it's epistemically and morally irrational, we persist in believing in Canada and our sovereignty rights. Our being just and accountable depends upon demonstrating by our actions that that's what we want to be. Only actions prove we have escaped our colonial perceptual reality and that we are ready to negotiate treaties grounded in mutual respect. Being just and accountable to Indigenous peoples requires, as Sebastian argued, decolonization. I've argued here that until we escape our colonial perceptual reality, we cannot understand what decolonization means. Thank you.
Thank you so much, Sandra. That was right on time. And now I'll turn to the chat. Robbie first asks, given that Indigenous notions of land and other things are fundamentally different and perhaps incompatible with those of the Canadian state, on what grounds do you assume that Canadian notions of justice are necessarily compatible with those of Indigenous peoples?
Oh, that's a very good question. Because I guess I would say short and sweet. I have read enough of Indigenous discussions of the rights that Indigenous people are claiming in Canada. And I would point most directly and succinctly to George Manuel's The Reconciliation Manifesto. There he demonstrates, I think, pretty convincingly that the arguments that I've been using for decades to establish that we are violating Indigenous people's rights and we should proceed to acknowledge their sovereignty and stop violating their right to their access to their lands. That's enough agreement for us to move into a mutually respectful treaty relationship. There will, I predict, be a problem in terms of, and Sebastian points this out too, Indigenous people's relationship to the land is something that we don't comprehend any more than we comprehend their immense notion of justice. Their immense notion of justice required they share with us, which opened the door for us to steal from them. But their notion of our responsibility to the land, which I use the expression, all my relations ethics to capture, is something that is going to be where we will have to collide and dialogue a great deal because we believe we should use, we believe we should abuse, we believe we should accumulate, we believe we should not preserve, we believe that you know, occupy, use, labor, take it all. Our approach to nature is destructive rather than aiming for a harmonious all my relations relationship. So I think at some point there, it is going to be a difficult conversation, but it should not be at the initial stage where we are establishing a just nation to nation relationship, because I am not arguing that Indigenous people have to exercise sovereignty the way that Western nations want to exercise it. In fact, I would be deeply disappointed if Indigenous people did that. I mean, they have the right to, because we have no right to tell them how. I especially have no right to tell them how. But I'm hoping that they will not. And actually, I'm also hoping that we will be blessed by their notions of a just relationship rather than ours. Because if they were to imitate what we have done, then we could expect a long suffering time. I'm not fearful of that though, because when I recommend a just treaty relationship, I'm thinking of justice. They will deliver their notion of justice. We just have to start living up to ours.
Beautiful, thank you. The next question is, okay, sure, yes. I'll go on with Jay's question first, before Melanie's. Thank you for this presentation, Sandra. Well done. Here is a puzzle for you. You write that colonial perceptual reality means it is false that Indigenous peoples did not treaty their sovereignty or underlying title. In other words, it is colonial to believe that they did treaty away their sovereignty and title. How then should we understand the James Bay Agreement? Cree leaders who signed the agreement after the Cree voted to accept it have been criticized by a large Cree minority for having signed away sovereignty. Were they wrong? Was sovereignty and title not signed away? Are you saying that it is alienable?
Oh my, Jay, those are all wonderful questions. I think what I'm going to say, first of all, is that, and it's something that you said, and I believe Sebastian, you and or Sebastian said it, a treaty process is a treaty process. A treaty, the peace and friendship treaties that were established between the British and the Mi'kmaq in Nova Scotia it's the establishment of a relationship, the establishment of agreement that we will share, we will work together, we will make decisions together. And the idea of, within our liberal theory, yes, sovereignty is kind of inalienable. I mean, sovereignty at the international level, even, you know, for decades, has been a big obstacle in nations, the United Nations, trying to improve the way in which human rights are respected in countries where they are ruled by dictators who are, you know, imposing terrible, terrible suffering on identifiable groups in their countries. So I think that our notion of sovereignty is one that, just like our notion of nation, needs a whole lot of work. And I don't think that the Cree or any indigenous group that enters into a treaty thinks they are giving up their sovereignty rights in the sense of their self-governing responsibilities in their territory. See, one of the problems for us is that we think of sovereignty as rights. We have entitlements to do, well, just about anything we want if we are sovereign in a nation. Whereas for the Indigenous people, self-governance is about governing self in responsible ways. And therefore, it seems to me that in the context of the Cree, given their commitment to responsibilities to the land, which is generally agreed upon, they couldn't give up their sovereignty, because then they would be giving up their right to speak on behalf of the land. And so, no, I don't think that they, and if you read the claims of political leaders from, you know, the beginning until, you know, present day, they're all saying that they still have sovereignty, that they did not give it up. That's why these rights are in Section 35. They fought to get them there. I don't think it's the best place for them to be, in the sense that the Supreme Court and the Canadian government can basically ignore them until something happens to push them into doing something about it. And I think Sebastian is probably onto something in thinking that I think you suggested that it's in the context of economic disputes that we see them in the court, right? So that's the case, you know, when it matters to us, then okay, we better start either saying something right or doing something right. And we opt mostly for words. The least cost to our sovereignty and our economic advantage is what we go for. And that's how we exercise our sovereignty over Indigenous people. That might not be all I should be saying. I'm going to look more carefully at your question, Jay, and I'll email you.
That definitely works. Or maybe if all of us are free, we could definitely stay back a little bit to chat about that. But let's try and get to Melanie's question. We do still have about 2 to 3 minutes. So Melanie Coughlin asks, I have a question about the capability approach that relates to Sebastian's discussion of the inadequate obligation to consult and Sandra's discussion of the persistent failure to perceive our shared reality. During this pandemic especially, many disabled people have been asking ourselves how long we have to accept the excuse we didn't know before that not knowing is itself considered culpable. Might this be considered a third order of unfreedom? That is not just an epistemic or hermeneutic injustice, but more specifically, the historically constituted agential ignorance that arises due to a systemic lack of meaningful inclusion at various levels of society.
That's a marvelous question. Does Jay want to go first?
You've said it. That's a marvelous question. So, you know, we understand what willful ignorance is for individuals. But what you're suggesting is that we need to expand, we need to understand that willful ignorance can exist for population groups. And if collective action is at all part of oppression, you know, this is the Stokely-Carmichael approach from the 1970s, that basically there's collective action on the part of white people. Some are just more active than others. And the others don't really very much question the position of advantage that they're in. And also that there's a kind of willful ignorance that kind of shields the condition of oppressed people from public view. Because part of the public just poo-poos it, says, well, that, you know. And of course, we know this is so typical in you know, settler consideration of indigenous peoples. So I think that's a really good idea, Melanie. Love to see you develop it. Keep me posted as you do. I'm really eager to see what you do with that idea. I think it could be very powerful and productive.
Sandra and Sebastian, do you want to respond as well?
You want to go first, Sebastian?
Go ahead.
Oh, okay. Well, I'll build a little bit on what Jay has said then. First of all, Melanie, a wonderful, wonderful question, and really brings together in a nice way the three presentations. It does seem to me that there is collective responsibility at the national level, provincial and municipal levels of government in Canada to act on the white problem. And I have to point to we talk about collective ignorance, and Jay happily used the expression willful ignorance. At this point, at 2020, I think if we're ignorant, there's a bit of willfulness in there. And the ones that I want to sort of plug and nudge are educators, Indigenous scholars all across Canada and probably all across the United States too, but we're talking Canada here, have been insisting that the university needs to be indigitized. Or, you know, we have to change the way that we do things in universities. And I don't know how many philosophers are with us today, but philosophy departments are probably among the worst in the humanities and social sciences in even beginning to think about what this might mean and how we could contribute, and I'll put it in terms of my paper, if any department at the university could have a responsibility to clarify a notion, it should be philosophers. I mean, tear apart my notion of colonial perceptual reality if you can. And build on a historical and normative knowledge that is based in reality. If we start anywhere in our conversations with the presumption that Canada is legitimate, then we have to justify that. And I would beg anyone who could do that to do it. I mean, how can we justify talking about incorporating Indigenous people into Canada? My nerves, what does that mean? They are the nations that should be doing the incorporating. We are ancestors of immigrants who think we are sovereign. Sorry, I kind of got carried away there, but it does seem to me that there is an epistemic problem that is rooted in our colonial perceptual reality. And there is a justice problem that arises out of it. And although I had no time to talk about the justice problems in our soul, I would want to say before we all sign off that I do think that our souls are contaminated by our colonial perceptual reality. As a non-Indigenous person, I grew up not having, because of the false beliefs or lack of beliefs that I had, I grew up not having the kind of informed sense of justice my soul needs in order, or needed, in order to have any sense of what non-Indigenous people in Nova Scotia were doing to the Mi'kmaq, to those who had the right to be there, that in no moral sense, in a way, I could claim. You could say I'm innocent of being born in Nova Scotia. Yeah, well, sure. But that does not relieve me from the responsibility of at least looking at what it means that I am living in Nova Scotia, looking at the advantages that I have being there, and how my being there and our being there has disadvantaged the Mi'kmaq and has violated their sovereignty in terms of self-governance and land use.
Beautiful, Sandra. So, Sebastian, I am so sorry. I'm not going to say that you can't answer, but at this point, I know we're a bit over time. So, people who have other obligations or commitments, you're definitely more than welcome to go now. The official conference, I would say, has come to an end, but I do want to keep on discussing all this because it's so interesting, and you know, we finally have a chance to come together and discuss, so why not? But before people leave, I did want to mention something that I am so sorry I did not mention at the beginning, and I apologize for that. And what I did want to mention is that all these presentations, or at least the 3 from today, come from the canceled 2020 conference that CSSPE did not get to do. So these papers were actually accepted to the conference last year. And our upcoming webinars, today is our first ever webinar in our webinar series. Our future webinars will be based on other accepted 2020 papers, which I think is really interesting, because now, instead of having CSSPE's conference squished into 2 or 3 days with a very packed full day, we're spreading out our presentations into maybe 3 or 4 different mini webinars, and hopefully we're hoping it will encourage more people to come, and also hopefully a bit more convenient than traveling to a place and congregate there. So feel free to please let us know if you have any suggestions on how CSSPE can run future events. I believe Diane has been so generous to send out an email, including an email in which you can ask questions or submit suggestions. So I just wanted to put that out there, and I do want to continue this conversation. So apologize for interrupting you, Sebastian, but please go ahead and address the question that Melanie had brought up.
I don't think I can add any more to that, to be quite honest.
That is totally fine. That's totally fine. In that case, let's give our presenters one more round of applause before we continue our discussion. Thank you so much for being here on a Sunday. This has been great. I thought it was very engaging and provided a lot of substance for us to think about. Does anybody have a burning question, or one that is in particular related to Sandra's talk? If not, I can go back in the chat and go through the older questions that were asked. Diane, do you think that's a good approach, or should I handle it differently? Let me just double check that the people who asked those questions are actually still here.
Yeah, and up to the presenters, I think you've been on for a while. And so if you'd like the opportunity, we could also, as you know, we'll save the chat and we could post your answers to the question either in video form or in text form on our website. So up to you all as well.
Yeah, how do the 3 of you feel? Would you want to answer more questions? That's a good point. Thank you, Diane, for bringing that up. Okay. Let's see. I think Philip's question was the first one we did not get to. And it was in response to Jay's presentation.
Okay. Philip and I have been having an ongoing private chat about that.
Okay, okay.
But happy to bring people in. It first came up saying that, look, if we can't help but in pursuit, if say white people can hardly help but contribute to systemic racism, just by going on and leading their lives and taking the advantages that are before them, then so if they can't do anything other than that, then how can it be wrong? And it's a philosophical question, right? Because normally our conception of wrong is based on an idea of personal responsibility and freedom, and the idea that people can do otherwise. So my first answer, which was kind of very limited, was, oh, maybe I'm going to have to be like Hobbes and show how we've got freedom and responsibility and wrongness, even if we've got responsibility and wrongness even if we don't have freedom, even if determinism prevails. I was really not too satisfied with that one. But then I brought up another metaphor that I just used in another webinar, and people really liked it. So if we think of the experience of systemic oppression as, you keep running up against these walls. There's one here, and there's one there, and there's one there, and there's one there. You keep running up against walls, right? It's being confined. So you're not free to make your life better, because however you try, you keep running into something. And I said, it's important to keep in mind that those walls are made up of people. So that's pretty graphic, isn't it? But the people are not necessarily malicious. Right, and this bears on one of the theoretical debates in critical race theory. One of the debates is racism necessarily a kind of maliciousness towards the racialized people? And arguably, different debate, that's a big debate, but one answer that I like is that, well, no, they don't have to be, right? But what do we have to say about them? Is there any kind of aspect of agency involved? Well, think about white flight. White flight does not have to be engaged in by haters, right? It could just be some quote unquote nice white parents who are, looking to their best advantage, And so when they look to the suburbs, they may not see in particular the absence of Black people of color, but they may see, oh, there are good schools out there, and this is the way we want to bring our family up, and yada, yada, yada. So the point is that the racial impact can be unthinking. Nevertheless, when you've got a whole group of people acting in particular ways, pursuing their own advantage in particular ways, and the impact of this is to keep other people from achieving the same advantage, when it is social exclusion is the result of this, then you have to say, look, there's something going on here. It's not like getting caught in a machine. That these are people doing things. They are benefiting. They are getting their own advantage out of this. And the result is that other people are disadvantaged. So I think it's, I don't know if I've convinced Phil of this, but maybe not, probably not. He's very, he thinks about these things quite a lot. And it was a good question for me, but I think it perhaps this is a case where, it challenges our ideas of how wrongness and responsibility can be related.
Could
Right.
I
is it on a related question, Sandra?
Could I comment on the question that was just being discussed and what?
Yes.
Okay.
Yes.
Thank you, Jay. As always, you were extremely informative in your answer. What I would like to jump in on is that my whole notion of colonial perceptual reality is actually based on the idea that we are not malicious. And even those that are not educating us properly or miseducating us, those of us who are perpetuating the growth and development of a good colonial perceptuality in each individual, each non-Indigenous individual, I don't want to hold them guilty of anything that is malicious. But I do think that Indigenous scholars in 2020 make it a whole lot easier for us to get clarification about our colonial perceptuality than it was for me in 1997 when I went to the Native Philosophy Project. So I think Sebastian is real proof that undergraduates are at last getting educated. I did not hear a word about colonization when I got, in 1988, I had 3 degrees in philosophy and had never heard of the Aboriginal rights problem. I was focusing on justice. No mention of Aboriginal rights. So we have come a long way, and we're far enough now into a world where non-Indigenous people can become informed about colonization and to be made to think about justice to Indigenous people. We've got the Indigenous people who are giving us the information that we need. And I notice I keep referring to Indigenous people because I would still be caught in what I call our colonial perceptual reality if I hadn't listened and been in the company of so many Indigenous voices. I think that, and I think you're another demonstration of this, Sebastian, because it seems to me that you were also benefiting from Indigenous voices in the conclusions that you were reaching in your paper. And that notion that we can excuse ourselves from culpability because we are ignorant is fast becoming something that we cannot utter truthfully. And if we are ignorant, then we can be accused of failing our moral responsibility. If we see there's a justice problem, we can do something and we do nothing, as Jay mentioned earlier, then we can hold you responsible. I mean, there's no excusing us after a certain point. Sorry, thank you.
Thank you. I think this is related to Philip's question to Jay, and if it is, and if you feel like you've already answered it, please just tell me to move on. But more explicitly, I wanted to ask if you think that oppression in the sense that we've been talking about today, is a necessary evil, or at the very least an inevitable harm.
No, it's not inevitable.
Okay. That's a bit too pessimistic?
We have, look, I'll say one thing about human beings is that we as a species have this real talent for exploitation of each other, right? And so, I mean, who knows what future forms of exploitation, may not be brought out that we can't even imagine at present. But it seems to me that, once we recognize unequal freedom, it's possible for people to, the thing about human beings also is, let's consider our moral psychology, right? I mean, we have some things in us that just won't put up ultimately with oppression. And so we do have within us a sense of compassion, most of us, except for like the diagnosable narcissists in this world, one of which will go unnamed, but you know who I'm talking about. sociopaths. So there are people like that, but most of us are able to feel compassion for other people. Most of us also have the capacity for perspective taking, the famous putting yourself in the shoes of the other. And most of us have a sense of fairness that comes out of this. I mean, that's a lot to work with. Right, that's a lot to work with in order to mobilize people. Here's another fact that is really conducive to change, that we can use the moral judgments that come out of our sense of compassion and our sense of fairness to identify who's with us and who's against us. Right, so the in-group, out-group psychology is not rooted once and for all time along racialized or historical or traditional group lines, right? That we also communicate to each other morally, and we recognize self and other that way. So that, and you put all these together, and you've also got the force of public reason. That is, we can recognize when the values have implications that are going to oppress people. We can recognize that, we can be critical of that. So I think that's enough. Given that we're like this, I think there's enough to say that oppression, on the one hand, oppression is not inevitable. There's no form of oppression that we cannot in principle get rid of. On the other hand, human beings have a terrible history of inventing new ones. So
yeah, exactly. Yeah. All right, great. I'm going to read one last question, which is directed to Sebastian. It was received in private chat. So Sebastian, you talked about the need for refinement and consistency in the law. How does UNDRIP changes Canada's relationship with Indigenous peoples?
Yeah, that's a good question. I think that it changes the relationship with Indigenous peoples only insofar as the Canadian or Canada as a country is willing to accept what's recommended in those recommendations. So while I think that it's definitely, those recommendations are important and they're very thorough. If you go and read them, there's no real ambiguity in what they're saying. It's very laid out and straightforward in what they're calling for. And I think that, again, I think it's just the willingness of Canada, the court to more so the government, the Canadian government, to accept those recommendations, and there needs to be some kind of force or some kind of voice to that, or convincing them that that is what they need to do. And I think that if there happens to be something that does arise where we do adopt all those recommendations full stop, I think that we could be seeing a relationship that definitely is one that resembles what Mr. Trudeau calls this nation to nation approach.
Awesome, thank you so much. Okay, and with that, we'll wrap up today's webinar. Thank you so much to the three presenters. It was beautiful. Thank you. It was very informative and we had a fruitful discussion. So thank you for that. And thank you for the people who have stayed. It was wonderful. I know we went overtime, and but it was worth it. So once again, thank you, Jay, Sebastian, and Sandra. Do you have any further questions, comments, or concerns?
I just want to say thank you so much. This is awesome. I'm happy that we had the time to do this.
Thank you to the organizers, and keep yourselves safe. Stay well.
Thank you so much.
Good last words. Thanks, Jay. And thank you, Sebastian. Very nice to meet you, Sebastian. And
Nice to meet you.
Nice to meet you all.